The bankruptcy laws were conceived to balance the interests of the debtor in getting a fresh start and the creditors in seeking a meaningful repayment on the amount owed by the debtor. Therefore, Congress and your state legislature decided what assets should be exempt or protected from your creditors. It was felt that a debtor needed to retain certain assets in order that they could get a fresh start in life. Most debtors who file bankruptcy in Florida use the Florida state exemptions. First, there is the homestead exemption that protects the home in which you live, provided you do not exceed the number of permitted acreage or the amount of equity you are allowed in your home. Then there is the Florida automobile exemption, which is usually limited to $1,000 equity per person in an automobile. There are certain cases in which a debtor is allowed more than $1,000 equity per automobile through what is referred to as the super exemption. The concept behind the automobile exemption is that the state legislature has deemed that a debtor in bankruptcy is allowed to retain an automobile, but if that automobile has more than the prescribed amount of equity, then the creditors should benefit from the equity in that asset. If an asset is not exempt, the Chapter 7 bankruptcy trustee can sell such asset at a public auction. For example, if a debtor has an automobile that has a fair market value of $9,000 and he is allowed an automobile exemption of $1,000, the bankruptcy trustee can sell the automobile at a public auction. If the high bidder pays $9,000 for the automobile, then the bankruptcy trustee will refund the debtor $1,000 and the remaining $8,000 will be paid to the creditors, minus the bankruptcy trustee's fee of roughly 25%. If the debtor wishes to retain the automobile, the bankruptcy attorney may be able to negotiate a buyback wherein the debtor essentially buys back the automobile by making monthly payments. Very few of our clients over the last 20 years have lost their automobiles to the Chapter 7 bankruptcy trustee. In a Chapter 13 bankruptcy, the Chapter 13 trustee cannot sell a non-exempt asset but seek a payment increase if the debtor wishes to retain such asset. Generally, the debtor in a Chapter 13 bankruptcy must pay his unsecured creditors the same amount of money they would receive if the debtor filed a Chapter 7 bankruptcy. This is what is known as the liquidation test, or the best interest of creditor test. In the above example, if the creditors were to receive $8,000 from the sale of the debtor's automobile in a Chapter 7 bankruptcy, then the debtor must pay roughly the same amount, usually less, to his creditors in a Chapter 13 bankruptcy.